Hello and welcome once again to the Constitution Study. My name is Paul Engel. I am so glad you came to join me today. We are here to return the Constitution to we the people. Today I have a very interesting discussion about a Supreme Court ruling, in this case Carpenter v. United States. And it's interesting not simply because of what gets covered, but for what I found when I was reading it and what it meant to me. So I'm glad you could join me here today. If you are a first-time listener, well, welcome. I think you've picked an auspicious episode to try out the Constitution Study. You can find more at the website, constitutionstudy.com. If you are a returning guest, thank you. Again, I think this is a very important episode because I'm going to apply one of my study rules, and that is you must allow the document, the words on the page, to form your opinion, not your opinion to form the words on the page. This particular opinion really got me in somewhere, and I'll talk about that a little bit more. If you go to the website, you can find other episodes for the Constitution Study. You can also sign up for the mailing list. I don't spam people. I'm basically letting you know what new is going on. You know, when I've got events coming up, I've released an essay. If you sign up, you get a free copy of the essay, How the 16th and 17th Amendments Destroyed the Republic. Any other events I have going on, I handle up there. You can also sponsor me if you so desire. There's a link for my Patreon site, patreon.com/Constitution Study. And you can help support this as I continue to work more to get the word out, to help people read and study their Constitution. So let's see. With that said, let's go on. Let's take a look at this particular opinion, Carpenter v. United States. I'm recording this early in July. As you probably know, if you follow the Supreme Court, they release their most controversial decisions usually mid to late June. They do them in large chunks, so it's been taking me a while to get through some of these. And I have to admit, this one kind of threw me under the bus. So let's take a look at it. This particular case, it's about the need for a warrant in order to get cell phone tracking data. So the question is, whenever you use a cell phone, every time your cell phone connects to a new cell site, all those towers you see, every time it connects to one of those, the phone company records the date, the time, and the location where you connected to their cell network. That makes sense. The question before the court was, does the government need a warrant in order to collect that information from the cell phone company? And that's really what this all came down to. Now, as I went through the opinion, I have to tell you, I started out with information about me should be private. And this kind of fits with some of previous courts' rulings about privacy. In fact, the cell site location information, or CSLI, the question is it private or not? Most of us carry our cell phones with us each and every day, all day, which means if you track this data, you get a fairly detailed records of where you are each and every day. Now, Chief Justice Robert wrote this opinion, and he found that data was covered under the Fourth Amendment. But I found some of the reasons rather interesting. Quoting him, "Thus, when an individual seeks to preserve something as private and his expectation of privacy is, quote, one that society is prepared to recognize as reasonable, close quote, official intrusion into that sphere generally qualifies as a search and requires a warrant supported by probable cause." See, Chief Justice Roberts states that the Fourth Amendment protections are incurred when someone seeks to preserve something as private. I find that interesting, since the language of the Fourth Amendment says nothing about a person's desire, only that they are secure from unreasonable searches and seizures. The Fourth Amendment starts out with the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated. See, this is a tiny little tidbit, but it's about who initiates the action. According to Chief Justice Robert, if I wish to keep it private, then it falls under the Fourth Amendment. However, that's not what the Constitution says. We're going to get more into this because this is going to, like I said, this one kind of threw me under the bus. See, the other reason the court found the way it did is a concern about how this particular case kind of sits between two previous sets of court precedents. We all know the Supreme Court is really interested in precedents until it isn't. Right? So basically, the question it strides this concept of a person's expectation of privacy in his physical location and movements, which the court has found, and a person's expectation of privacy and information voluntarily turned over to third parties, referred to as a third-party doctrine. See, in short, while the court had previously decided that sharing of location data with a third party would normally allow it to be collected by government officials without a warrant, the fact that this data is, quote, detailed, encyclopedic, and effortlessly compiled, close quote, led the court not only to extend this third-party doctrine, or not to extend the third-party doctrine to cover this case. Third-party doctrine is the idea that once I turn information over to a third party, I have no expectations of privacy. It no longer requires a warrant or probable cause in order for the government to gain access to it. Quoting again from the syllabus of the opinion, quote, a majority of the court has already recognized that individuals have a reasonable expectation of privacy in the whole of their physical movements. Allowing government access to cell site records, which, quote, hold for many Americans the privacies of life, contravenes that expectation. See, the court uses the point that individuals have a reasonable expectation of privacy in the whole of their physical movements as a determining factor for the requirement for a warrant. This originally seemed to me to be a reasonable position regarding an individual's right to be secure in their persons. But while the court found this right to privacy, it also makes a point that this decision is meant to be interpreted narrowly. This is not meant to disturb other third-party doctrine, other third-party precedents. This is where I started coming into some issues. But we'll get more on that later. I'm sorry to tease, but I want to set the opinion because this is how I came to my current opinion, current understanding. If we look at the dissents to this particular opinion, Justices Ginsburg, Breyer, Sotomayor, and Kagan, they joined with the opinion. But if we look at the dissents, we find something very interesting. One, the dissents are really numerous and voluminous. The court opinion takes 23 pages. The dissents alone take 91. So let's look first at Kennedy's dissent. Again, this one was joined by Thomas and Alito, and it's rather interesting. Quote, the new rule the court seems to formulate puts needed, reasonable, and accepted lawful and congressionally authorized criminal investigations at serious risk in serious cases, often when law enforcement seeks to prevent the threat of violent crimes. And it places undue restrictions on the lawful and necessary enforcement of powers exercised not only by the federal government, but also by law enforcement in every state and locality throughout the nation. Close quote. See, I found this interesting because it appears to me that these justices, their primary concern is not the rights of the people, but law enforcement investigations, and whether or not they will actually have to take the time to get a warrant to acquire this data. Isn't it interesting that these three dissenters are concerned with, quote, accepted, lawful, and congressionally authorized investigations, but not with constitutionally authorized ones? Their concern is that law enforcement seeks to prevent the threat of violent crime. Fine, I understand that. That's good, but they are not concerned about the rights of those being investigated. While the FBI did get a court order to access these records, the standard for that order is reasonable necessity, meaning the government needs only to show to a government-employed judge that they have a reasonable need to access the data. In short, these three justices seem to think it quite reasonable to establish the power of government to investigate people with minimal suspicion, much less evidence of wrongdoing. They support this position based on the fact that the court has held it in the past. In other words, precedents. Quote, The court has twice held that individuals have no Fourth Amendment interests in business records which are possessed, owned, or controlled by a third party. On the contrary, I find this quite unreasonable for the government to be allowed to search data or records about me without probable cause. The Fourth Amendment does not protect government's ability to search based on reasonable necessity, but on probable cause. The fact that previous courts have failed in their duty to apply the Constitution to cases before them does not give the justices cover to continue to do so. Just because someone got away with this bad behavior in the past doesn't mean these men get to do it today. Of course, we're going to get into the question. It's like, well, what is reasonable? And it's important to understand. The Webster's 1828 dictionary defines reasonable as governed by reason, being under the influence of reason, thinking, speaking, or acting rationally or according to the dictates of reason, as the measure must satisfy all reasonable men. So Kennedy goes on to say, here's the only question necessary to decide is whether the government searched anything of Carpenter's when it used compulsory process to obtain cell site records from Carpenter's cell phone service providers. See, since the Fourth Amendment protects us from unreasonable searches of our persons, houses, papers, or effects, the question we should all be asking is, what are our papers and what are our effects in the modern world? See, according to these three justices, business records held by a third party, even though about you, are neither your papers nor your effects. Therefore, as long as the government goes through some legal process to access those records, everything is fine. Do you find that reasonable? Now life gets interesting, because let's start looking at the Alito dissent. This one was joined by Thomas, and I found it very interesting because they go beyond Kennedy's dissent, and to find more issues. Quoting from Alito's dissent, the court's reasoning fractures two fundamental pillars of Fourth Amendment law, and in doing so, it guarantees a blizzard of litigation while threatening many legitimate and valuable investigative practices upon which law enforcement has rightfully come to rely. See, here it appears Justice Alito's concern is more with the efficacy of law enforcement than with the rights of the citizens. Quote, first, the court ignores the basic distinction between an actual search, dispatching law enforcement officers to enter private premises and root through private papers and effects, and an order merely requiring a party to look through its own records and produce specified documents. I'm getting a little confused here because apparently, according to Alito, a search only is a search if it's of your private premises. But somehow ordering someone to search through their records is not a search because he calls it a look-through. I was not part of looking through these records, but I'm pretty sure they used some sort of search algorithm to find the records they were looking for. Quoting again from Alito's dissent. Second, the court allows a defendant to object to the search of a third party's property. This is also revolutionary. See, Justice Alito kind of misses the point. Mr. Carpenter didn't object to the search of a third party's property, at least not as far as I know. He objected to that information being used against him in court. And I find it funny how it wasn't a search in his first point, it's just a look through the records. But according to Alito, in this point, it's a search. So now we get to Thomas's dissent. And this is where my understanding, my thought process around the third-party doctrine and the Fourth Amendment really started to come off the rails. So let's read. Reading from the Thomas dissent, this case should not turn on whether a search occurred. It should turn instead on whose property was searched. The Fourth Amendment guarantees individuals the right to be secure from unreasonable searches of their, quote, their persons, houses, papers, and effects, close quote. In other words, each person has a right to be secure against unreasonable searches in his own person, house, papers, and effects. By obtaining the cell site records of Metro PCS and Sprint, the government did not search Carpenter's property. He did not create the records. He did not maintain them. He cannot control them, and he cannot destroy them. Neither the terms of his contract nor any provision of law makes the records his. The records belong to Metro PCS and Sprint. So I have said for quite some time that there would be an issue with metadata, cell phone metadata, and the third-party doctrine. And this idea, your information about your metadata about calls is not yours. And Thomas put it in words which, to me, were better than anything I had come up with. You didn't create the data. You didn't own the data. You didn't possess the data, and you don't have the ability to destroy the data. It's not your data. It is data about you. And this is an important distinction. The fact that the records were about Mr. Carpenter does not, under current law, grant him ownership and, by extension, Fourth Amendment protections. As much as I wish it were otherwise, I have to agree with Justice Thomas that the Fourth Amendment, as it is written, does not cover information about someone, only what they create or own. Now, if Justice Thomas kind of started me off the rails, I thought the Gorsuch dissent was beautiful. I think Gorsuch summed up the issues at hand quite well. And it's a rather long quote, so it's going to take me a minute to get through. But the opening of his dissent is important. So quoting from the Gorsuch dissent. In the late 1960s, this court suggested for the first time that a search triggered by the Fourth Amendment occurs when the government violates a, quote, expectation of privacy, close quote, that, quote, society is prepared to recognize as reasonable, close quote. Then, in a pair of decisions in the 1970s applying the Katz test, the previous case, the court held that a reasonable expectation of privacy doesn't attach to information shared with third parties. This is Smith v. Maryland. By these steps, the court came to By these steps, the court came to conclude the Constitution does nothing to limit investigators from searching records you've entrusted to your bank, accountant, and maybe even your doctor. What's left of the Fourth Amendment? Today we use the internet to do almost everything. Smartphones make it easy to keep a calendar, correspond with friends, make calls, conduct banking, and even watch the game. Countless internet companies maintain records about us, and increasingly for us. Even our most private documents, those that in other eras would have been held locked safely in a desk drawer or destroyed, now reside on third-party servers. Smith and Miller teach that the police can review all of this material on the theory that no one reasonably expects any of it to be kept private. But no one believes that if they ever did. What to do? It seems to me we could respond in at least three ways. The first is to ignore the problem, maintain Smith and Miller, and live with the consequences. If the confluence of these decisions and modern technology means the Fourth Amendment rights are reduced to nearly nothing, so be it. The second choice is to set Smith and Miller aside and try again using Katz reasonable expectations of privacy jurisprudence that produced them. The third is to look for answers elsewhere. And I look at this and I'm like, I kind of understand. Gorsuch has put this all together. The problem the court has in this case, is one of its own making. It started with this idea of privacy, which they made up with Katz, and then Smith and Miller have taken it so far that the Fourth Amendment basically means nothing anymore. It leaves everyday Americans with little protection for their privacy, their property, even their records, since so much of what we do, so much of the information we maintain and require are stored on third-party systems. Think of all the information you share via email or on Facebook or Twitter or any of the other social media platforms. Do you use Google Docs or iCloud or OneDrive to store your important documents? How about any online accounting software like that available from Quicken or QuickBooks? See, under Smith and Miller, the court has found that you have no expectation of privacy for this information since you've entrusted it to a third party. Think of all the information you store in the cloud. The government doesn't require a warrant to go get that. But Justice Gorsuch asked the $64 million question, what do we do? Quoting from his dissent, Miller held that a bank account holder enjoys no reasonable expectation of privacy in the bank's records of his account activity. That's true, the court reasoned, even if information is revealed on the assumption that will be used only for limited purpose and the confidence placed in a third party will not be betrayed. See, the court found in both the Smith and Miller cases, you have no expectation that anybody you do business with will actually keep your information private. Even if you've got it in writing, even if it's part of a contract or a terms and conditions or a privacy agreement or a privacy document, you have no expectation of privacy. The court has put the government right in between two individual parties and said we can have access to all that data. Gorsuch goes on to say, can the government demand a copy of all your emails from Google or Microsoft without implicating your Fourth Amendment rights? Can it secure your DNA from 23andMe without a warrant or probable cause? Smith and Miller say, yes, it can, at least without running afoul of cats. But that result strikes most lawyers and judges today, me included, as pretty unlikely. Gorsuch again goes on later to say, what then is the explanation of our third-party doctrine? The truth is, the court has never offered a persuasive justification. The court has said that by conveying information to a third party, you, quote, assume the risk, close quote, it will be revealed to the police and therefore lack a reasonable expectation of privacy. So what happens if we get rid of Smith and Miller? If we say, no, that's no good anymore, what then happens? Well, according to Gorsuch, there's a second option. What if we dropped Smith and Miller, third-party doctrine, and retreated to the root of Cat's question whether it's a reasonable expectation of privacy in data held by third parties? Rather than solve the problem with the third-party doctrine, I worry this option only risks returning us to its source. After all, it was Katz that produced Smith and Miller in the first place, close quote. See, the answer is, if we drop Smith and Miller and go back to Katz, we're back to where we started, and that is this fictitious question of reasonable expectation of privacy. By the way, words that don't exist in the Constitution. Gorsuch goes on, the amendment's protections do not depend on the breach of some abstract expectation of privacy, whose contours are left to the judicial imagination. Much more correctly, it protects your, quote, person and your houses, papers, and effects. Nor does your right to bring a Fourth Amendment claim depend on whether a judge happens to agree with your subjective expectation to privacy is reasonable or not. Or is a reasonable one. Under its plain terms, the amendment grants you the right to invoke its guarantees whenever your protected things, your person, your house, your papers, or your effects, is unreasonably searched or seized. Period. In short, the expectation of privacy appears nowhere in the Fourth Amendment. It is a creation out of whole cloth by the court, in the Katz opinion. So where do we sit? What's my conclusion? What do I read out of all of this? Well, I have to admit, I want information about me to be protected, regardless of whether it is in my possession or not. Unless I voluntarily expose that information to the public, I want the government to prove probable cause before they go searching through it. So while I believe the court's opinion matches the expectation of most Americans, it does not follow the letter of the law. It appears the court tried to do the right thing the wrong way and for a very wrong reason. In addition to some of the dissent show that there's a continuing and disturbing leaning of the court to support government efficacy above personal rights and liberties. According to the court, Miller and Smith hold that individuals lack any protected Fourth Amendment interest in records that are possessed, owned, or controlled only by a third party. But that misses the question at hand. In the modern society, the modern world, our persons, our papers, our effects extend beyond simple physicality. Does my person include information about where I am or what I'm doing? Do my papers include documents and other information that I store in the cloud? I believe it is well past time for Congress to do the right thing and to propose another amendment to our Constitution, extending the recognition of papers and effects to extend to the digital world and to protect records about us as well. I propose the following language be changed in the beginning of the Fourth Amendment. The right of the people to be secure in their persons, houses, documents, papers, and effects, including data and records created by them or about them, against unreasonable searches and seizures, shall not be violated. See, Congress passed the HIPAA law in part to protect the privacy of our medical records, records we do not create, own, or possess. It is time they protect all of our records about us, and it's time that they do it the right way. Otherwise, we will continue to live at the whim of what those in black robes consider reasonable. So I hope this made you think. I hear a lot of people talking about cell phone data and my cell phone data and my metadata, and it's not really yours. And it's a fact that the world has changed, and Congress has not helped the Constitution keep up. We have not forced Congress to help to do its job to amend the Constitution as realities change, as life changes, as the processes that in 18th century America were unthinkable now become every day. I hope you found it interesting. I hope you'll follow more. I have some more decisions I'm researching, and I'll be writing blog posts and posting podcasts about. I hope you'll come back. I hope you'll read the Constitution. And I hope when you read the Constitution and you read these decisions, you let the facts, the written word on paper, change your mind and not do like the court has done for so many decades, try to make the words match what you want them to say. It means it doesn't always come out the way you like, but it does come out the way the founders created it. And the fact that we haven't done our job to help update the Constitution doesn't mean we get to ignore it and we get to try to make it say something else. That's what happens in a banana republic, not in the greatest nation, the greatest republic the world has ever seen. So I thank you for joining me. I hope you'll come back again. I hope you found this interesting, and I hope to see you again the next time on the Constitution Study.